Right. Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick and Bruno. We've got two questions today. One is coming from one of our regular viewers, Red Fritz. And Red Fritz, in summary, is having a difficulty here, Bruno, with a tenant that's staying in his property, which he actually wants to sell. The tenant is actually not allowing Red Fritz or the estate agent into the property for them to actually market and to put up for sale. The tenant is also obviously now behind on rent too, and is sabotaging the whole process. He has tried to make contact with the tenant and he's just not responding. And then obviously he's worried that he's paying the rates and the taxes and the levies as well. And obviously it's becoming, he's losing a lot of money on this. And now he wants to know how long will it take to actually issue him with a month-to-month notice, and how much would, of course, the cost be of the post eviction in this instance.
Cool. Okay. So maybe let's start right at the beginning. Also having a look at the question, so it's quite comprehensive. So starting right at the beginning, the relationship between a tenant and landlord, what does this lease actually look like? So mention is being made in the question of it being a month-to-month lease agreement. So I don't know how that came about. Was it always a month-to-month lease agreement, or did it become a month-to-month lease agreement upon expiration of a fixed term lease, or whatever the case is? But so for in the meantime, though, if we look at this from the relationship perspective, so to give notice on a month-to-month lease agreement is simply 1 month's notice, right? And then the lease is terminated. Both parties can give that notice period. So where people sometimes get confused is there's a difference between a no fault cancellation, which is what I refer to it. So no fault cancellation versus a breach cancellation. So normally if a person is a breach of a lease agreement, you give them certain days business notice in terms of the CPA, so 20 business days notice, and you cancel the lease if they fail to remedy their breach. A no fault cancellation does not require there to be any fault. So this could be the best tenant in the world. You can terminate the lease on a month-to-month notice. You don't have to convince anyone that you've got any good reason for doing it. It's just your entitlement to do it, right? So that's the first thing to bear in mind. So what I do in situations like this, especially if there's going to be an expectation that you have to give 20 business days anyway, I normally actually terminate on a no fault basis, because then there's no disputes. Or I do it on both, saying, look, either or, this thing's going to be terminated. So I try and word it in a way where I use both remedies, if you want to put it like that. Depends on the circumstances. Sometimes you can, sometimes you can't. Often I try, but it depends which one's going to be pushed back the most. Some people argue that it's not a month-to-month lease agreement. So that's the first thing, is you have to actually give your notice. Until you've given your notice, either by way of breach or no fault cancellation, you're going to get stuck, because you can't actually start any of the processes without doing that, right? So that's the first thing. So now the second thing is regarding the fact that the rental's not being paid, as an example, and that the landlord is stuck paying property rates and he's falling into arrears and it's becoming an issue. So this is your typical scenario where the tenant falls into arrears. There's nothing new to be said about it, except, look, unfortunately, they are in breach. So you're going to need to terminate this lease. It's the only way to get the ball rolling. After this point, you can choose to follow the debt collection process in order to collect the amounts that they haven't paid. It's a long conversation, but in short, most of those collection processes aren't that successful. I mean, there's often like a 10 to 20% success rate on collections. So I'd be very careful with that. My primary focus is always do the eviction, get default judgment on the collections. You can always decide later if you want to pursue it or not. But you need to start the eviction process. And again, to do so, you need to give the proper notice. So there you go. I mean, that's the long and short of that side of the answer. The access to the estate agent entering the complex So no, it's not necessarily defined as hijacking, but it is unlawful occupation. And at the end of it, the tenant is normally unlawfully refusing people being given access to the property. Most lease agreements do have a provision allowing access to market the property. If the person's there unlawfully, then yes, their refusal of access is just outright unlawful. However, you can't take the law into your own hands. So you can't just go there, kick down the door, and start walking up and down the property. It's not lawful. We do have something that we designed a few years ago called an access application. We did it a lot with sales and execution, where the occupiers were refusing potential purchasers at the sale and execution from entering the property. So you can do that. It's basically going to court saying, I've got a right, and they don't have a right. So my right is stronger. I need access to the property for A, B, and C. I am suffering prejudice by not getting access to the property. Give me an order that allows me, and then we've got a set of things. So I wouldn't, it's not a DIY application. You literally need to ask for a process of, I will give 24 hours notice every time I want to visit the property. This is what it's going to look like. Times are between this time and this time. Get an order allowing a locksmith to unlock the property if the person refuses to open the door, etc., etc., etc. So there's a whole process. So can you get access to the property? Absolutely. Now, what you need to ask yourself is, do you want to get access to the property, or do you want an eviction order? Because marketing a property to potential tenants, but not knowing when the property is going to be empty. Oh, sorry, memory. So sorry, you said you want to sell the property. So if you want to sell the property, that's fine. Get access, get a purchaser. But the one important question I need to ask is a purchaser truly going to buy a property with an unlawful occupier on the property? And what sort of price do you anticipate getting in those circumstances? So I've seen it happen. It's not to say that people won't buy properties in distress where there's occupiers, but they're not going to pay you top dollar for it. So you do need to decide now. Either you get this purchaser in, he makes an offer at a whim, and he takes over the eviction obligations, which, like I said, we work with a lot of guys that do that, or you complete the eviction. But getting an access application only to later have to complete the eviction anyway, you might actually be wasting your time and money. So just consider whether you really want to follow both avenues, or whether you just want to do the eviction good and proper, complete it, get an order, kick the guy out, do the property up, and and there you go. And remember what I always say with tenants, especially month-to-month tenants that have been there for a short period of time, they've got no vested interest. You give them a couple of notices here and there, and at some point or another, when it comes down to them having to go to court or spend money on an attorney, a lot of the times they leave. So you're looking at like a 70% success rate that this thing doesn't see the inside of a courtroom. So going to your last question on costs, costs vary. I mean, I've done evictions that have been like 1 million rand. I've done evictions that cost 1,000 rand because you send out a letter of demand and the guy moves out. So really costs are very difficult to estimate. What I can say is, by the time I issue the application, let's say it costs between 10 to 15 to send out letters, issue the application, go to court, serve it, whatever. By that time, 60-70% of the time, the guys decide to move out. So yeah, it's kind of like an average cost, if you want to put it like that. It doesn't include a court order. It's just the practical, effective cost I've noticed of getting the person out in practice. I hope that answers everything.
Yeah. I do think as I'm going down the questions now, that you have definitely covered all the questions. Red Fritz, obviously, as you've heard, the first step is obviously to get out those notices, and especially with the access application, it is complicated. It's not something that you can just perhaps do yourself. You have to actually get an attorney involved. So please feel free to contact us at Bruno Simao Attorneys or Nicholas and his team at